Virginia prosecutors are revolting against their governor's most recent gun control legislation.
Abigail, you have nothing to say? Abigail.
Her approval rating, she is the lowest rated governor in modern Virginia history for a reason.
Have you nothing to say about that? Are you not going to address it?
This is the absurdity. This is the perfect example of the absurdity in Richmond and the attack on our Second Amendment rights.
Lawsuits are in the works, and even some prosecutors around the Commonwealth say they won't enforce it.
Tell you that I'm going to dog-ear this floor speech and put it in the category of I told you so that we can get back to this.
Okay, we've got huge developing news coming out of Virginia, and this one is absolutely bonkers. The Virginia State Police just declared they are implementing mandatory background checks on private firearm transactions. Once more, even though a standing court injunction, a legally binding order from Virginia's 24th Judicial Circuit Court, plainly states they are prohibited from doing so. Gun Owners of America and the Virginia Citizens Defense League are now submitting a motion to hold the Virginia State Police in contempt. Let me repeat that. Two of the nation's biggest gun rights groups are requesting that a court find the Virginia State Police in contempt for deliberately breaking a permanent injunction. If you reside in Virginia and possess firearms, this impacts you personally right now, this very day. If you attempt to complete a private firearms deal, a transfer between two private parties that has been permitted throughout the Commonwealth's entire existence, the Virginia State Police are conducting background checks on those deals as though the court order never happened. If you fall in the 18 to 20 age bracket, this hits you even harder. The whole basis the court invalidated this law to begin with was that it rendered it practically impossible for you to practice your constitutional right to own and carry weapons. The court has already decided this was unlawful. It isn't a recommendation. It isn't a non-binding opinion. It is a permanent injunction, and the state police are disregarding it because the Virginia legislature commanded them to. That ought to alarm every firearm owner across this nation, not merely those in Virginia. If a state legislature can just enact fresh legislation instructing police to disregard a judicial decision, then judicial decisions safeguarding your freedoms are completely worthless. So let me break down precisely how we arrived at this point, because the roots of this run far deeper than the public grasps. The initial law at the heart of this matter is Virginia Code, Section 18.2308.25. That's the Universal Background Check Statute mandating background screenings on private firearm transfers. Gun Owners of America and the Virginia Citizens Defense League took this statute to court, contending it violated the Constitution. The lawsuit landed before the 24th Judicial Circuit Court of Virginia. Judge Eames, who presided over the case, delivered a verdict that was about as unambiguous as any judicial ruling could be. The court stated, quote, "The court finds itself left with one option at this time, and that is to strike the statute entirely." The court granted the plaintiff's request for permanent injunctive relief, enjoining the administration, enforcement, and imposition of Virginia Code Section 18.2308.25, end quote. That constitutes a permanent injunction. Permanent, not provisional, not contingent, not open to legislative reversal. The court declared this statute is unconstitutional and you may not enforce it. End of story. The central logic was simple and anchored in well-settled Second Amendment case law. The universal background check mandate, as enforced, effectively prevented people aged 18 through 20 from obtaining firearms via private transfers. Because the federal background check platform NICS, that's the National Instant Criminal Background Check System, doesn't run checks for people below 21 buying handguns through federally licensed sellers. The real-world consequence of mandating background checks on every private transfer was to erect a total blockade for 18 to 20-year-olds. The court determined this was an unconstitutional violation of their right to own and carry arms under both the Second Amendment and the Virginia Constitution. This aligns squarely with the analytical structure laid out in New York State Rifle and Pistol Association v. Bruin, groundbreaking 2022 ruling from the Supreme Court. That ruling demands that every firearms regulation align with the historical pattern of firearms regulation. At the nation's founding, the court examined this statute, applied the Bruin standard, and concluded there exists no historical parallel for preventing legal adults from obtaining firearms. House Bill 1525, designed to bar anyone below 21 from buying, transferring, or owning a firearm. What this measure accomplishes is instructing the Virginia State Police to enforce something that a court within the Commonwealth of Virginia has plainly stated they are forbidden from enforcing. We can harken back to the era of the young men and women who battled to liberate America roughly 250 years past. This will advance. It will be contested. It will collapse. I'm going to say called it. Now this is where it becomes genuinely scandalous. Quote, earlier this year, the Virginia legislature, under Democratic control, approved what can only be characterized as a legislative nullification of a court order. They approved a fresh bill that basically instructed the Virginia State Police to enforce the universal background check mandate on private transfers, in spite of the already existing permanent injunction. This wasn't some oversight. This wasn't a situation where lawmakers failed to notice the court's decision. Members of the Virginia House GOP took to the floor and directly cautioned their fellow legislators that this bill, which has been tied to HB 5P 1525, flatly conflicts with both the 24th Circuit Court's permanent injunction and the Bruin ruling from the United States Supreme Court. One representative spelled it out in language that couldn't have been more direct. What this measure accomplishes is instructing the Virginia State Police to enforce something that a court within the Commonwealth of Virginia has plainly stated they are forbidden from enforcing. He pushed further. He highlighted that the Fifth Circuit Court of Appeals has already decided the underlying age-based matter, in a case touching on identical legal principles and siding with Second Amendment protections. He observed that the United States Supreme Court has been weighing related petitions on this precise question, and then he issued a forecast. He stated, this statute will be challenged, it will collapse, and he would say called it, not with satisfaction, but with sorrow. Commonwealth will have flushed millions of taxpayer dollars down the drain defending what is, in his judgment, plainly indefensible. He was correct, and now we are witnessing his forecast unfold before our eyes. Let me frame this within the wider picture, because this isn't occurring in isolation. Nationwide at this moment, we are observing a trend where state governments, especially those with anti-Second Amendment majorities, are brazenly defying court rulings that shield your freedoms. We witnessed it in California with magazine prohibitions following Duncan v. Bonta. We witnessed it in Illinois with legal challenges to the assault weapons prohibition. We are witnessing it in New York, where the state legislature approved fresh carry limitations practically the instant the Supreme Court struck down their previous permitting system in the Bruin ruling. Virginia is now executing the identical strategy. The approach is straightforward, and it is ruthless. Lose in court, then approve a new statute that achieves the identical outcome. Compel gun owners to sink additional funds and additional hours contesting the new statute, and maintain your unconstitutional policy active for as long as you can while the judicial process drags on. It is governance through exhaustion, and now they have tacked on a fresh chapter to the strategy, which is to approve a statute that explicitly commands police to disregard the court ruling altogether. That is what is unfolding in Virginia at this moment, and it is a frontal assault on the rule of law itself. The contempt motion submitted by Gun Owners of America and the Virginia Citizens Defense League is the proper response, and it is the sole response available at this juncture. They are returning to the court that handed down the permanent injunction and declaring your order is being breached. Hold the Virginia State Police in contempt. Will this lead to anyone serving time? Likely not. I'll be straight with you. Will Governor Spanberger face individual legal repercussions? Almost definitely not, at least not in the immediate future. What will most probably occur is the court will restate its injunction, perhaps with more forceful enforcement terms, and command the state police to halt. The state police will obey the court order because at that stage they will have no alternative. But here's the catch. The harm is occurring as we speak. Right now, while the enforcement rolls on, every private transfer being subjected to an unconstitutional background check at this moment is a violation of an individual's rights. Every 18 to 20-year-old being blocked from buying a firearm through a private transfer right now is having their constitutional freedoms trampled under a statute that a court has already invalidated. That isn't abstract injury, that is tangible. Looking forward, I believe the Supreme Court is going to begin sorting this out. We have numerous cases working their way through the system that address these exact matters, age-based limitations, the breadth of Bruin's historical standard, and the boundaries of state authority to govern private firearms transfers. But that is a procedure that spans years, and in the interim, states like Virginia are capitalizing on the delay. So here's the current state of play. If you're in Virginia, the state police are presently enforcing universal background checks on private transfers in defiance of the permanent injunction from the 24th Circuit Court. Gun Owners of America and the Virginia Citizens Defense League have lodged a motion for contempt. That motion will be argued before the court, and I anticipate a decision fairly soon, given the pressing nature. Your protections under the court's initial ruling remain intact. The injunction is still legally enforceable. The state police are merely electing to disregard it at the legislature's instruction. Keep a close eye on this situation. I will deliver an update the instant the court rules on the contempt motion. That's all for today, folks. Catch you in the next video.